Hello and a very good day to everyone. My name is Lavanya Anak Perempuan Balan. Along with me today are my fellow firmmates who are Aiman Daniel and Johan Arif from Firm 16 Khairul Azman and Partners. So today I'm in privilege to sail the discussion on our topic known as advocate and solicitor not to appear for a party represented by another advocate and solicitor. If I may recall, Raja Aziz Adrus once said that the legal profession's traditional role has been and still is to uphold and preserve the rule of law, and in discharging this central function without fear and favor, it has to come to be regarded as the sentinel and guardian of the fundamental rights of the individual. This shows that every individual has their right to be represented by a lawyer, be it in a criminal or civil cases. It is well pronounced that a lawyer is akin to a doctor, that a lawyer cannot cherry-pick their client. It is known as cap-rank rule, codified under Rule 2 of Legal Profession, Practice and Etiquette Rules 1978. But the question is, can the client choose another lawyer if he wishes to substitute his first appointed lawyer to another one? Or can the lawyer himself decide to let go of his or her client? This brings us closely to our cardinal of discussion, where the prevalent provision would be under Rule 54 of Legal Profession, Practice and Etiquette Rules 1978. What does Rule 54 says? It says that advocate and solicitor not to appear for a party represented by another advocate and solicitor. To draw an analogy, Hasbury's Law of Malaysia, Legal Profession, Volume 12, Number 2, provides if the name of any advocate and solicitor or the name of his firm appears on the records for any party in any matter or proceedings, or an advocate and solicitor is known to be acting for a party in a matter whether in a court or not, no other advocate and solicitor shall knowingly agree to appear or to act or to continue to appear or to act for such party in such matter or proceeding. To give practicability to Rule 54, Bar Council Rulings 11.06 further mentioned that lawyers on record shall represent their client unless discharged in accordance with the relevant rules of the court concerned. Thus, as long as the named advocate and solicitor remains, his service shall be valid. As for the new solicitors, they should obtain the consent of the previous solicitors on record before promptly filing a notice of change of solicitors. A notice of change of solicitors is necessary for new advocates to proceed taking over the matter, replacing the former solicitors whose services has been terminated or decide to no longer represent his client. The former lawyer should also give consent if any of this situation happens. Well, this brings us to the main picture of this issue.
Now, let's go deeper into the issues. These issues, based on our extensive research, came from decided cases. First, whether advocate and solicitor's failure to file notice of change of solicitors amount to professional negligence. And second, whether the advocate and solicitor name on record can refuse to discharge themselves and give consent to the new advocate and solicitor to represent their current client. For the first issue, in order to obtain consent, or perhaps in other words, to appear as new solicitor, consent must be given by the former solicitor as stated under Rule 54. Nonetheless, Rule 54 does not make it requirement to file a notice of change of solicitors. However, Bar Council Rulings 11.06 bracket 4 stated new advocate and solicitor must file promptly a notice of change of solicitor. As a matter of fact, this is provided under Order 64, Rule 1 of Rules of Court. However, what will be the consequences of failure to file a notice of change of solicitors? With reference to case of Tek Cruz dan Berhad and Nur Hamizah binti Hamzah and others, plaintiff sued the defendant for professional negligence in the conduct of civil suit between plaintiff and Miracle Asset Builders Sedanan Berhad. The plaintiff sought to recover a whopping amount of 5.85 million from the defendant. The plaintiff initially appointed the first defendant as its solicitor, but however, then they terminated and appointed the second and third defendant to handle their case. Failure on behalf of first defendant to abide to plaintiff instruction for the second defendant to have access over relevant documents to respond to the letter, and failure to return telephone call as to inform the matters at the Court of Appeal. because of this omission by the first defendant, the court found that the only first defendant is liable for professional negligence because the matters before the Court of Appeal being struck off, which attribute them for professional negligence and not informing to the second and third defendant. And now we are going to the second issue, which is continuous from the first issue. What if such consent will be given within the ambit of unreasonably withheld? And what is unreasonably withheld to begin with? So, in the case of Ms. Albert Ding, Lee and partners, and Chu Choi Mei, whereby Judicial Commissioner Avril Merritt Peters held that plaintiff was morally wrong to refuse to discharge themselves. So, when they refuse to discharge themselves, it amounts to misconduct under Section 94 of Legal Profession Act 1976. The facts of the case, where defendant gave instruction to Ms. Vui and Yi to inform the plaintiff that they would take over the matter from the plaintiff. However, after providing them with final tax invoice, so they wish that they could take the divorce matter before the court. However, the reason why the defendant suddenly terminated the service from the plaintiff was due to exorbitant fees. So the plaintiff argued that they refused to discharge themselves and refused to give consent to the new advocate and solicitor was because there were agreements that had been undertaken by the defendant. The court held that since the retainer agreement between the former solicitor and the defendant was in pursuit of coercions and there were prohibited contingency fee and as well as provided unreasonable fee in the retainer agreement, which the plaintiff had known about it, and whenever their client asked for them to withdraw themselves, that would be as soon as practical for the former advocate and solicitor to make change, to file promptly notice of change of solicitor provided under Order 64. So that's all from me.
So now we are aware the issue within the realm of Rule 54. In a way to overcome this issue, it would be great usefulness the amendment should be made to further clarify the rule. For instance, the insertion of the necessity for new solicitors to receive relevant clause paper before filing a notice of change of solicitors. Hence, the suggested amendment of Bar Council Ruling 11.06 Clause 3 would be: the new solicitors must receive the relevant clause paper from the solicitors on record and should obtain the consent of the solicitors on record before filing a notice of change of solicitor. As to the second issue, that the amendment of Bar Council Ruling 11.06 Clause 3 should be read together with Rule 54A. The clause, the consent shall not unreasonably withheld, in Rule 11.06 Clause 3 should be elaborated further. On what situation will constitute the consent be unreasonably withheld, and in what situation the consent is not unreasonably withheld due to the term on its generic meaning is too subjective. As of now, the case of Ms. Albert Ding, Lee and partners against Chu Choi Mei, the act of refusing to discharge at the time the misconduct had been done constitutes unreasonably withheld as opposed to Rule 11.06 Clause 3 of Bar Council rulings, where the consent supposedly shall not be unreasonably withheld. With further elaboration on this clause, it will help the advocates and solicitors to understand and comply with Rule 54A, which reads together with Bar Council Ruling 11.06 Clause 3. At the end, Rule 54 of LPPER serves a practical provision where every advocate and solicitors must ensure their potential client is not represented by any other advocates or solicitors. Ergo, advocates and solicitors are prohibited to represent a client for already being represented. Rule 54 provides disclosure to client that has been aggrieved or looking for other alternatives in catering for justice. Thank you.